Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional financial, legal, or tax advice. Retirement account division and divorce laws vary significantly by state and individual circumstances. You should conduct your own due diligence and consult with a qualified attorney or a certified financial planner before making any decisions regarding your assets. Imagine standing in a glass-walled office in the heart of Manhattan or downtown Los Angeles. You are 52 years old. For 3 decades, you have been the person who stayed late, the person who maxed out their contributions every single January, and the person who watched the S&P 500 like a hawk. You have built a $2 million nest egg. You've done everything right. But today, a stranger in a black robe signed a document that effectively cut that fortress of security in half. In modern American cities, the 401k has replaced the family home as the single most contested asset in a divorce. While a house is made of brick and mortar, a 401k is made of time, compound interest, and your future. When that is split, you aren't just losing money. You are losing years of your life that you can never get back. This is the reality of the 401k divorce in the 2020s, a financial phenomenon that is quietly dismantling the retirement dreams of thousands of professionals across the United States. By the time we finish this deep dive masterclass, you will understand the complex mechanics of how retirement assets are actually divided in the current legal landscape. We are going to deconstruct the myths surrounding community property, reveal the hidden tax traps that can turn a 50-50 split into a 40-60 disaster, and look at the historical trends that have made retirement accounts the primary battleground for modern litigation. This is about more than just numbers on a screen. It is about protecting the literal decades of work you have invested in your future. To understand why this is happening with such intensity today, we have to look at the historical shift in how Americans save. 40 years ago, the primary vehicle for retirement was the pension. In a pension world, the company took the risk and the payout was a fixed monthly check. If a couple divorced, they might split that future check, but the underlying capital stayed with the institution. Today, we live in the era of the 401k, a defined contribution world where the individual bears all the risk and holds all the capital. In high cost of living cities like San Francisco, Seattle, or Boston, many professionals are choosing to rent luxury apartments rather than buy real estate. Consequently, their 401k or 403b often represents 80 to 90% of their total net worth. When a marriage ends in these urban hubs, there is no house to sell or equity to trade. There is only the retirement account. Let's look at a case study to illustrate the gravity of this shift. Consider a hypothetical couple in Austin, Texas. We will call them Mark and Jennifer. Mark is a software architect who has been at the same firm for 15 years. During their 12-year marriage, Mark's 401k grew from $50,000 to $800,000. In Texas, a community property state, the law generally views any wealth accumulated during the marriage as belonging to both parties equally, regardless of whose name is on the account. Many people mistakenly believe that because they were the one who earned the salary and they were the one who chose the investments, the money is theirs. The legal reality in modern American cities is far more communal. In this case, the $750,000 of growth is considered marital property. Without a prenuptial agreement, Jennifer is potentially entitled to $375,000 of that account. The process of moving that money is where the complexity truly begins. You cannot simply cut a check from a 401k without triggering massive tax consequences and early withdrawal penalties. This is where the Qualified Domestic Relations Order, or QDRO, comes into play. A QDRO is a legal judgment or order for a retirement plan to pay investment interest to a spouse, former spouse, child, or other dependent. This is a specialized area of law that sits at the intersection of family law and federal ERISA regulations. If a QDRO is drafted incorrectly, the person receiving the money could be hit with a sudden 20% federal tax withholding, plus state taxes, effectively evaporating a massive chunk of the settlement before it ever hits their bank account. In many modern American cities, we are seeing a trend called the gray divorce. This refers to couples over the age of 50 ending long-term marriages. For this demographic, the 401k division is even more catastrophic because they have less time to recover from the loss of compound interest. If you lose $500,000 at age 30, you have 30 years of market growth to make it back. If you lose it at 55, you are looking at a fundamental shift in your quality of life. You may have to move from a city center to a more affordable suburb, or you may have to push your retirement date back by a decade. Historical trends show that the financial recovery for men and women after a late-life retirement split is significantly slower than for younger divorcees. We also have to discuss the premarital versus marital contribution debate, which is a major point of contention in modern litigation. In cities like New York, where many people marry later in life after establishing their careers, the calculation becomes a nightmare. If you had $200,000 in your 401k before you got married, and that specific $200,000 grew to $500,000 through market appreciation while you were married, is that growth marital or separate? The answer varies by jurisdiction and requires forensic accounting to determine. Courts in different states use different formulas. Some use the active/passive test, while others use a more equitable distribution approach. This means that two people with the same financial profile could end up with vastly different outcomes simply because one lives in Miami and the other lives in Chicago. Furthermore, we must address the issue of 401k loans. In many high-earning households, it has become common to take loans against a 401k for down payments on property or to fund a startup. In a divorce, these loans are often treated as a liability that must be settled. If the loan isn't paid back during the division of assets, it can be treated as a distribution, leading to immediate tax liabilities. Imagine trying to navigate a divorce where you are already losing half your assets, and then realizing you also owe the IRS 30% of a loan you took out 3 years ago because the divorce triggered a default on the plan's terms. As we move forward through this series, we will examine the specific steps involved in the valuation of these accounts. We will look at how to handle unvested employer contributions, which are common in the tech hubs of Silicon Valley and Seattle. If your company has promised you $100,000 in matching funds that don't vest for another 3 years, how is that valued today? Does your spouse get a wait-and-see order? Or do you have to buy them out now based on a projected value? These are the high-stakes questions that define the modern American divorce. The goal of this deep dive is to move past the surface-level advice and look at the actual data and legal mechanisms. We are living in a time of unprecedented financial complexity. The days of simply splitting the furniture and moving on are over. In the modern American city, your 401k is your legacy, and understanding how it is handled in a legal split is the most important financial education you may ever receive. We will look at how to properly document premarital assets, the importance of accurate plan valuations, and why your choice of a QDRO specialist can be just as important as your choice of a divorce attorney. This is part 1 of a journey into the financial heart of the American family. Stay with us as we peel back the layers of the 401k divorce. To understand the true weight of a 401k split in 2026, we have to look past the total balance on your monthly statement and peer into the engine room of asset valuation. In modern American cities, the 401k is rarely a simple bucket of cash. It is a complex ecosystem of pre-tax contributions, employer matches, and varying investment vehicles that react differently to market volatility. When a marriage dissolves, the court doesn't just look at the number at the bottom of the page. It initiates a process of forensic tracing that can feel like an invasive species in your financial garden. Imagine if you are Sarah, a project manager at a major aerospace firm in Seattle. It is early 2026, and after 14 years of marriage to David, a high school administrator, the relationship has reached its conclusion. Sarah started her 401k 3 years before she met David. At the time of their wedding in 2012, Sarah's account was worth $85,000. By the time they filed for divorce in late 2025, that account had ballooned to $1.2 million due to consistent contributions and a historic decade of growth in the technology and aerospace sectors. The first major hurdle Sarah and David face is the determination of separate versus marital property. In many jurisdictions, that initial $85,000 Sarah brought into the marriage is considered her separate property. However, it is not as simple as subtracting $85,000 from $1.2 million. The court must account for the passive appreciation of those initial funds. If that $85,000 was invested in a broad market index fund that tripled in value over the course of the marriage, Sarah might argue that $255,000 of the current balance is hers alone. But David's legal team might argue that Sarah used marital funds to pay the administrative fees on the account, or that she actively managed the portfolio during the marriage, potentially converting separate property into marital property through a process known as commingling. This brings us to the first critical step in the deep dive of 401k valuation: the creation of a chronological contribution audit. In 2026, automated financial tools have made this easier, but the legal interpretation remains archaic. A forensic accountant must go back through 14 years of statements to identify every single contribution made by Sarah and every single dollar matched by her employer. In many modern American cities, the employer match is a massive point of contention. If the company match for 2025 hasn't hit the account yet but was earned during the marriage, is David entitled to half of it? Historical trends in Washington state suggest that earned but unvested or uncredited benefits are often treated as marital property, even if they don't physically appear in the account until after the divorce is finalized. Now, consider a different scenario in a city like Denver, Colorado. We will look at Michael and Elena. Michael is a consultant who changed jobs 3 times during their 10-year marriage, rolling over his 401k from one provider to another each time. Elena stayed at home to raise their 2 children. In Denver, an equitable distribution jurisdiction, the court does not necessarily aim for a 50-50 split. Instead, it looks for a fair distribution based on the length of the marriage, the economic circumstances of each spouse, and the contributions of the non-earning spouse to the household. Because Michael rolled over his accounts multiple times, the paper trail is a mess. This leads to the nightmare of the missing basis. If Michael cannot prove the value of his 401k at the exact moment he married Elena because the old brokerage deleted the records after 7 years, the court may default to assuming the entire balance is marital property. In the high-stakes environment of 2026, where a 10-year-old account could have grown by 400%, the inability to produce a single PDF from 2016 could cost Michael hundreds of thousands of dollars. Step 1 for anyone in an urban professional environment is the immediate preservation of all legacy digital statements. Do not assume your HR department or the brokerage will keep them forever. The valuation process also has to account for the current year's market realities. In the spring of 2026, we are seeing significant shifts in interest rates and sector-specific downturns. If Michael's 401k is heavily in energy stocks that took a 20% hit the week before the divorce trial, should the valuation be based on the date of filing or the date of the final decree? In some cities, the valuation date is set the moment the papers are served. In others, it is a moving target that shifts with the market until the judge signs the order. If the market recovers between the filing and the finalization, the spouse who keeps the account might get a windfall. If it crashes further, they might be left with a hollow shell of an asset, while their ex-spouse walks away with a fixed cash settlement based on an outdated, higher valuation. This leads us to the concept of the buyout versus the spin-off. In many modern divorces, couples try to avoid splitting the 401k directly because of the administrative hurdles of a QDRO. Michael might offer Elena a larger share of the home equity or a brokerage account in exchange for keeping his 401k intact. This is often an attractive option for the account holder who wants to maintain their compound interest trajectory. However, the calculation of a buyout is fraught with peril. $1 in a 401k is not equal to $1 in a savings account. The $401,000 is burdened with a future tax liability that could be 24% or higher, depending on Michael's projected tax bracket in retirement. If Michael buys out Elena using after-tax cash from a savings account, he is effectively overpaying her unless they apply a tax adjustment discount to the 401k value. We must also examine the role of plan administrators in these urban hubs. Large corporations in cities like New York or Chicago often have incredibly rigid 401k plan documents. Some plans do not allow for partial distributions. Others might charge a $1,000 fee just to review a QDRO. Step by step, the process involves obtaining the Summary Plan Description or SPD. This document is the Bible of your 401k. It dictates exactly how the plan handles divorce, what forms are required, and how long the process takes. In 2026, with the rise of remote work and decentralized HR, getting a human on the phone to explain these nuances is harder than ever. Historical trends show that the most successful outcomes in 401k divisions occur when both parties agree on a neutral valuation expert early in the process. This avoids the battle of the experts, where 2 forensic accountants charge $500 an hour to argue over the passive appreciation of a tech stock from 2019. In a city like Boston, where legal fees can quickly reach 6 figures, the cost of fighting over the valuation can sometimes exceed the value of the disputed amount itself. The complexity deepens when we consider the interaction between 401k accounts and other retirement vehicles like IRAs or Roth 401ks. If Sarah in Seattle had been doing a backdoor Roth conversion every year of her marriage, the tax implications of splitting those specific funds are vastly different from her traditional 401k. The Roth funds are after tax, making them more valuable per dollar than the traditional funds. If David's lawyer doesn't understand the difference, David might agree to a 50-50 split of the traditional account, while Sarah keeps the entire Roth account, leading to a massive disparity in their actual future purchasing power. As we conclude this deep dive into valuation and legal geography, we have uncovered how the specific city you live in and the quality of your digital record keeping can change your financial future by hundreds of thousands of dollars. But even if you get the valuation right, and even if you perfectly trace every dollar back to 2012, there is a silent predator waiting at the end of the process. This predator doesn't care about your marriage or your career. It only cares about the code. What happens when the money actually moves? Most people think a QDRO is the end of the story, but for many, it is just the beginning of a tax nightmare that can trigger immediate penalties and permanent loss of wealth. In the next part of our masterclass, we are going to look at the devastating tax traps of the 401k split and how a single clerical error can alert the IRS to a distribution you never intended to take. We will explore the mechanics of the transfer and why the first 30 days after the judge signs the order are the most dangerous period for your retirement security. Stay tuned for part 3. The danger period begins the second the judge's pen leaves the paper. Most people in major metropolitan areas like Chicago or New York believe that once the court order is signed, the financial battle is over. In reality, the most treacherous part of the 401k journey is the execution of the transfer. In the year 2026, the speed of digital finance has increased, but the bureaucracy of retirement plan administrators remains a fortress of red tape. If you do not navigate the next 30 days with surgical precision, you risk triggering a tax event that can systematically dismantle your settlement. Let's look at a case study involving Marcus, a high-level marketing executive in Manhattan. Marcus had a 401k valued at $1.4 million. As part of his divorce settlement with his spouse, Elena, they agreed on a 50-50 split. The judge signed the Qualified Domestic Relations Order, or QDRO, on a Tuesday. Marcus assumed that his job was done, and that the brokerage would simply handle the rest. However, Marcus failed to realize that a QDRO is not an automatic trigger. It is a request for the plan administrator to review and qualify the order against the specific rules of that individual company's retirement plan. The first major tax trap involves the difference between a 401k and an IRA when it comes to early withdrawal penalties. Under Internal Revenue Code Section 72T(2)(c), there is a specific exception for distributions made to an alternate payee pursuant to a QDRO. This means that if Elena, who is only 42 years old, needed immediate liquidity to secure a new apartment in a high-cost city like New York, she could potentially take a cash distribution from Marcus's 401k without paying the 10% early withdrawal penalty that usually applies to anyone under the age of 59 and a half. This is a critical nuance that many professionals miss. If that money is first rolled over into Elena's own IRA, and then she withdraws it, that 10% penalty exception vanishes. Historical trends show that thousands of divorcees lose tens of thousands of dollars because they roll the money into an IRA first, thinking they are being safe, only to find they have locked their liquidity behind a 10% penalty wall. However, just because the 10% penalty is waived doesn't mean the money is tax-free. This leads us to the 20% withholding trap. Imagine if Elena decides she wants $100,000 of her settlement in cash to cover moving expenses and legal fees. When the plan administrator processes that QDRO distribution directly to her, they are legally mandated by the IRS to withhold 20% for federal income taxes immediately. Elena doesn't receive $100,000, she receives $80,000. Furthermore, if her total income for 2026, including this distribution, puts her in a higher tax bracket, such as the 32 or 35% range common for urban professionals, she will owe the difference when she files her taxes in 2027. We have seen case studies where individuals spend the entire $80,000, only to realize months later they owe another $15,000 to the IRS and $5,000 to the state, with no liquid assets left to pay the bill. Step by step, the execution phase must follow a rigorous protocol. First, the draft QDRO should be sent to the plan administrator for pre-approval before the judge ever sees it. In 2026, many large employers use automated portals for this, but the language must still be exact. If the plan document says that assets are valued at the end of the quarter, but your QDRO specifies the date of divorce, the plan administrator will reject the order. This can lead to months of delays, during which time the market value of the 401k can fluctuate wildly. Imagine if the market drops 15% while you are arguing with a plan administrator over a comma in your legal filing. You are effectively losing money in real time due to a clerical mismatch. Another scenario involves the phantom asset trap. Let's consider Jason, a tech lead in San Francisco. Jason had a 401k with a heavy concentration in his employer's stock. During the divorce, the stock was trading at $200 a share. By the time the QDRO was finally processed and the assets were segregated into a separate account for his ex-wife, the stock had dropped to $150. Because the QDRO was written to award a specific dollar amount rather than a percentage of shares, Jason was forced to liquidate significantly more of his remaining shares to satisfy the dollar-denominated debt to his ex-wife. He ended up with 30% less of the retirement account than he had initially projected. Potential outcomes in volatile markets suggest that defining the split as a percentage of the account as of a specific date, rather than a fixed dollar amount, can offer a more equitable hedge against market movement for both parties. We must also discuss the role of the alternate payee's behavior during these 30 days. Once the account is segregated, the recipient spouse usually has a window of time to decide where the money goes. If they do nothing, the money often sits in a default money market fund or a low-interest stable value fund within the original plan. In a high-inflation environment like we are seeing in parts of 2026, leaving $500,000 in a cash-equivalent fund for 6 months while you figure out which brokerage to use can result in a significant loss of purchasing power. The step-by-step detail here is to have a destination IRA established and ready to receive the funds the moment the plan administrator signals that the segregation is complete. For those living in modern American cities, the state tax implications are the final layer of this trap. While federal law, through ERISA, governs how 401ks are handled, state tax laws govern how that income is treated. In a state like California or Massachusetts, the tax bite on a non-rolled over distribution can be massive. If you are an urban professional earning a high salary, adding a $200,401,000 distribution to your taxable income for the year could push you into the highest possible state tax tier. This is why forensic planners in 2026 often suggest structured distributions over multiple tax years, although this requires a level of cooperation between ex-spouses that is often difficult to achieve. The complexity of these transfers is further compounded by the existence of multiple 401k accounts from different employers. Many professionals in 2026 have a trail of zombie 401ks from previous jobs. Each of these requires its own separate QDRO, its own plan administrator approval, and its own set of fees. It is not uncommon for a single divorce to require 4 or 5 different QDROs, each with a processing fee ranging from $500 to $1,200. Failure to account for these administrative costs in the initial settlement can lead to a death by 1,000 cuts scenario for the retirement nest egg. As we have seen, the path from a judge's signature to the actual arrival of funds is lined with tax traps, administrative hurdles, and market risks. Understanding the difference between a cash distribution and a direct rollover is the difference between a secure future and a massive tax bill. But what if the money you are fighting over doesn't even belong to you yet? In many of the most successful companies in the United States today, the real wealth isn't in the contributions you've already made, but in the contributions the company has promised to make in the future. What happens to the thousands of dollars in employer matching funds that haven't invested yet? What happens to the 401k loans that were used to pay for a wedding or a home renovation? In the next part of our masterclass, we are going to dive into the world of unvested assets and the hidden debt traps that can turn a 401k split into a legal nightmare. We will explore how to value money that technically doesn't exist yet and what happens when the 401k you are splitting is actually a series of IOUs. Prepare for part 4, where we tackle the vesting cliff and the loan default disaster. To navigate the landscape of a 401k divorce in 2026, we have to confront the most deceptive number on your financial dashboard: the unvested balance. In high-competition hubs like Seattle, Silicon Valley, and the Research Triangle of North Carolina, the modern employment contract is built on the concept of the golden handcuffs. Your 401k portal might show a total balance of $500,000, but a significant portion of that, perhaps the employer's matching contributions from the last 3 years, exists in a state of financial limbo. This is the vesting cliff, and in the eyes of a divorce court, it is a mathematical puzzle that can lead to years of litigation. Imagine if you are Chloe, a senior lead at a biotechnology firm in Boston. It is 2026, and Chloe has been married to her husband, Marcus, for 8 years. Chloe's 401k has grown substantially, largely due to a generous corporate matching program where the company contributes dollar for dollar up to 6% of her salary. However, the company uses a 5-year graded vesting schedule. This means Chloe only truly owns 20% of those matching funds for every year she remains with the firm. If she leaves today, she forfeits the unvested portion. In a divorce, the question becomes, is Marcus entitled to a share of money that Chloe hasn't technically earned yet, but was contributed during the marriage? Historically, courts in many American cities have moved toward the wait-and-see approach, also known as the deferred distribution method. Under this framework, the court issues an order that doesn't trigger an immediate payment, but instead stakes a claim on the funds once they vest. The complexity here is staggering. If Chloe gets divorced in 2026, but her final match doesn't vest until 2029, Marcus's legal team has to ensure the QDRO is written to remain active for years, tracking Chloe's employment status and the eventual movement of those funds. Step by step, the calculation often involves what is known as a coverture fraction or the Brown formula. This is a mathematical ratio where the numerator is the number of months the spouse participated in the plan during the marriage, and the denominator is the total number of months the spouse has participated in the plan up to the date of vesting. For Chloe, if she worked 60 months during the marriage while the match was accruing, and it takes 60 months to vest, the fraction is 1-to-1. But if she stays at the company for another 3 years post-divorce before the money is liquid, the denominator grows, potentially diluting Marcus's share. Potential outcomes vary wildly based on whether the court chooses this deferred method or the immediate offset method. In an immediate offset, a forensic accountant attempts to calculate the present value of that future unvested money. They apply a discount rate, accounting for the risk that Chloe might be fired or leave the company before the money vests, and Marcus receives a lump sum from a different asset, like the house or a savings account today. In the volatile job market of 2026, where tech layoffs and corporate restructuring are common, calculating that risk factor is less of a science and more of a high-stakes negotiation. If you overvalue the unvested match, Chloe overpays Marcus for money she might never actually receive. If you undervalue it, Marcus loses out on a significant portion of the marital estate. While the vesting cliff is a trap of the future, the 401k loan is a trap of the past that explodes in the present. In many modern American cities, where the cost of living has outpaced wage growth, professionals have increasingly turned to their 401ks as a personal bank. As of 2026, taking a loan against a 401k to fund a primary residence down payment or to consolidate high-interest credit card debt has become a standard financial move. But when the marriage ends, that loan becomes a toxic liability. Consider the case of Robert, a mid-level executive in Chicago. 2 years ago, Robert took a $50,000 loan from his 401k to renovate the kitchen in the family's suburban home. He has been paying it back through automatic payroll deductions. Now, in the middle of a divorce, his 401k statement shows a gross value of $400,000 and an outstanding loan balance of $35,000. The net value is $365,000. The first conflict arises in how the debt is characterized. Robert's spouse, Sarah, argues that the $400,000 is the marital asset to be split, and the $35,000 debt is Robert's personal responsibility because the loan is in his name. Robert argues that the money was used to increase the value of the marital home, which Sarah is also seeking a share of, and therefore the debt should be shared. If the court agrees with Sarah, Robert is hit with a double loss. He loses half the gross value of the 401k and remains solely responsible for paying back the loan with his post-divorce income. But the real disaster occurs if Robert loses his job or decides to leave the company during the divorce proceedings. Under current IRS regulations, if an employee with an outstanding 401k loan terminates their employment, they generally have until the due date of their federal income tax return, including extensions, to repay the balance or roll it over to an IRA. If Robert cannot come up with $35,000 in cash while simultaneously paying for a divorce and a new apartment in Chicago, the IRS treats the unpaid balance as a deemed distribution. In 2026, the consequences of a deemed distribution are brutal. The $35,000 is added to Robert's taxable income for the year. If he is already in a high tax bracket, he could owe upwards of $10,000 in federal and state taxes. Furthermore, if he is under the age of 59 and a half, he is hit with a 10% early withdrawal penalty. This is a $3,500 tax, simply for being unable to pay back his own money during a life crisis. Historical trends show that 401k loan defaults are one of the leading causes of post-divorce bankruptcy among middle-class professionals. To mitigate this, the 2026 strategy for 401k loans requires a detailed provision in the separation agreement. You must decide: will the loan be paid off using other marital assets before the 401k is split? Or will the spouse receiving the QDRO transfer take a pro rata share of the loan liability? Most plan administrators will not allow a loan to be split between two people. This means the person holding the account almost always bears the immediate risk of a job loss-triggered tax event. We are seeing more cases in urban courts where judges are requiring the in-kind distribution of 401k assets to account for these loans. For example, if Robert owes $35,000, the court might award Sarah $35,000 less from the 401k to compensate Robert for the fact that he is carrying the debt. But this requires a high level of financial literacy from both the attorneys and the judge to ensure the tax-affected math is actually fair. The complexity doesn't stop at the loan balance. We must also look at the lost opportunity cost. The $35,000 Robert took out was not invested in the market during the time it was a loan. If the S&P 500 grew by 15% during that period, the account is actually worth less than it would have been if the loan hadn't existed. Forensic accountants in 2026 are increasingly being asked to calculate this shadow loss to determine if one spouse disadvantaged the marital estate by taking a low-interest loan for a non-essential purpose. As we have seen, the 401k is not a static vault of cash. It is a living, breathing contract subject to vesting schedules and internal debts. Whether you are dealing with the invisible money of a vesting match or the very real debt of a 401k loan, the way these are handled in your final decree will dictate your financial stability for the next decade. But there is one more asset that many people forget entirely. One that isn't managed by a brokerage or an HR department, but by the federal government itself. While you are fighting over your 401k, there is a parallel system of retirement wealth that is accruing in the background, governed by rules that date back to the 1930s. What happens to your Social Security benefits after a 10-year marriage? Can you claim your ex-spouse's benefits without them ever knowing? In the next part of our masterclass, we are going to look at the intersection of private 401ks and public Social Security, and the 10-year rule that could be the most valuable piece of information for any divorcing spouse in America. Stay tuned for Part 5, where we reveal the hidden government safety net. While the 401k is a private fortress you build with your employer, Social Security is the federal backbone of the American retirement system. In the high-velocity environments of cities like Philadelphia, Phoenix, or Miami, where career shifts are frequent and 401ks are often fragmented, Social Security represents a stable, inflation-adjusted baseline. But for a divorcing couple in 2026, Social Security operates under a completely different set of rules than a private retirement account. You cannot split a Social Security benefit with a qualified domestic relations order. You cannot trade a portion of your future check for a larger share of the house. Instead, you must navigate the federal 10-year rule, a statutory threshold that can be worth hundreds of thousands of dollars over a lifetime. Imagine if you are Amanda, a nonprofit director in Philadelphia. It is 2026, and she is ending her marriage to Thomas, a high-earning cybersecurity consultant. Amanda spent several years out of the workforce raising their children and later worked for organizations with modest 401k matching programs. Thomas, conversely, has maxed out his contributions for 2 decades. While they are currently dividing Thomas's $2 million 401k, Amanda's legal team is looking at a date on the calendar with intense scrutiny: their 10th wedding anniversary. The 10-year rule dictates that if a marriage lasted at least 10 consecutive years, a divorced spouse is entitled to claim benefits based on their ex-spouse's work record, provided they are at least 62 years old and remain unmarried. For Amanda, this is a game-changer. If she meets the 10-year requirement, she can potentially receive a benefit equal to 50% of Thomas's full retirement age amount, if that amount is higher than her own benefit. In the context of 2026, where the maximum Social Security benefit has adjusted for several years of inflation, the difference between Amanda's own modest benefit and 50% of Thomas's high-earner benefit could be over $1,500 a month. Historical trends show that many couples in urban centers, fueled by the stress of a failing relationship, rush to finalize their divorce at the 9-year or 9.5-year mark. This is often a massive financial oversight. If Amanda and Thomas finalize their divorce at 9 years and 11 months, Amanda loses the ability to ever claim on Thomas's record. Step by step, The calculation of the 10-year period is measured from the date of the marriage to the date the final divorce decree is signed by the judge. In 2026, we are seeing a strategic trend where matrimonial attorneys in cities like Boston or Washington, D.C., are intentionally slowing down the litigation process to ensure their clients cross that 10-year finish line. This is not about being difficult. It is about securing a federal benefit that the ex-spouse does not even have to pay for. This brings us to one of the most misunderstood aspects of Social Security in a divorce: the impact on the earner. Thomas might be worried that if Amanda claims benefits based on his record, his own monthly check will be reduced. However, under federal law, the benefits paid to a divorced spouse have zero impact on the benefits paid to the primary earner or the primary earner's current spouse. It is a derivative benefit, not a split benefit. In our Philadelphia case study, Thomas will receive his full entitlement, and his second wife, should he remarry, will also receive her full entitlement. Amanda's claim is handled entirely by the Social Security Administration as a separate transaction. Another critical mechanism to understand in 2026 is the independent entitlement rule. Usually, a spouse cannot claim benefits until the primary earner has actually applied for their own benefits. However, if a couple has been divorced for at least 2 continuous years, the claimant spouse can apply for benefits based on the ex-spouse's record, even if the ex-spouse is still working and hasn't applied yet. This provides a level of financial autonomy that is vital in high-cost-of-living cities. If Amanda is 65 and needs the income to maintain her lifestyle in Philadelphia, she doesn't have to wait for Thomas to retire at 70. As long as they have been divorced for 2 years and he is at least 62, she can move forward. But there is a trap: the remarriage rule. Potential outcomes for Amanda change drastically if she decides to marry someone else. If she remarries, she generally loses the right to claim on Thomas's record unless her new marriage ends by death, divorce, or annulment. In the dating culture of modern American cities, this creates a bizarre financial incentive. We are seeing more urban professionals in their 60s choosing to cohabitate rather than legally remarry specifically to protect their derivative Social Security benefits from a previous 10-year marriage. We also have to consider the divorce survivor benefit. If Thomas were to pass away after they had been married for 10 years, Amanda would be entitled to 100% of his benefit amount, rather than just 50%. For a woman like Amanda, whose own retirement savings were diminished by years of domestic labor, this survivor benefit acts as a secondary insurance policy that is often more valuable than the 401k she received in the divorce settlement. The interaction between the 401k split and Social Security is where the true masterclass of financial planning occurs. If Amanda receives $1 million from Thomas's 401k via QDRO, that is a finite pool of money. If the market crashes in 2027 or 2028, that pool shrinks. Social Security, however, is a lifetime annuity with a cost of living adjustment. By securing the 10-year marriage requirement, Amanda is diversifying her retirement. She has the market-based asset of the 401k and the government-backed asset of the Social Security derivative benefit. In 2026, forensic accountants are increasingly looking at the total value of the divorce, which includes these non-liquid future federal benefits. They might calculate that the Social Security benefit Amanda is entitled to has a present value of $400,000 based on her life expectancy. This can be used as leverage during the negotiation for other assets. For instance, Thomas might argue that since Amanda is getting this massive future benefit from his work history, he should keep a slightly larger share of the current liquid 401k. However, because Social Security is a federal right and not a marital asset, many judges are hesitant to allow an offset, meaning the lower-earning spouse in a 10-year marriage often comes out significantly ahead if they play their cards right. Step by step, if you are approaching a divorce in a city like Chicago or Seattle, you must gather your marriage certificate and verify the exact date of your union. You must then compare this to the projected date of your divorce decree. If you are at 9 years and 8 months, the cost of waiting 4 months to sign the final papers could be the most profitable financial decision of your life. As we have explored, the intersection of private 401ks and federal benefits creates a complex web of timing and legal strategy. But what happens when the 401k isn't just a standard account? What if it includes high-risk investments, company stock options, or the increasingly popular but legally complex mega backdoor Roth? In modern American cities, the elite workforce isn't just saving in traditional 401ks. They are using advanced tax-shielding strategies that are notoriously difficult to untangle in a courtroom. In the next part of our masterclass, we are going to dive into the high-net-worth 401k, the complexity of stock-heavy portfolios, and how the insider knowledge of one spouse can lead to a massive disparity in the final split. We will look at how to value a portfolio that is top-heavy with volatile tech stocks, and the specific dangers of the 2026 market. Stay tuned for Part 6, where we enter the world of the Executive 401k. The Executive 401k is not merely a larger version of a standard retirement account. It is a multi-layered financial vehicle designed for tax optimization at the highest income brackets. In the specialized economies of San Jose, Seattle, and New York City, top-tier professionals are no longer limited to the standard contribution limits that the average worker faces. By 2026, we have seen the widespread adoption of the mega backdoor Roth and the utilization of net unrealized appreciation strategies, both of which create a labyrinth of tax-advantaged buckets within a single 401k plan. When these accounts enter a divorce proceeding, a simple 50-50 split becomes a mathematical impossibility without a forensic understanding of how these layers interact. Imagine if you are Daniel, a vice president of engineering at a major semiconductor firm in San Jose. It is 2026, and Daniel's 401k is valued at $4.8 million. To the untrained eye of his spouse's attorney, this is a single marital asset. However, Daniel's account is actually composed of 4 distinct sub-accounts: a traditional pre-tax bucket, an employer matching bucket, a standard Roth 401k bucket, and a massive after-tax bucket that has been systematically converted into a Roth through the mega backdoor strategy. The mega backdoor Roth is a primary source of conflict in high-net-worth urban divorces. In 2026, the total contribution limit for a 401k, including employer matches and after-tax contributions, has reached levels that allow executives to funnel over $70,000 a year into their plans. If Daniel has been contributing $30,000 a year into the after-tax portion and immediately converting it to Roth status, that specific slice of the 401k is growing tax-free forever. His traditional pre-tax slice, however, is a ticking tax bomb that will be taxed at ordinary income rates, potentially as high as 37 or 40%, when it is eventually withdrawn. If the divorce decree simply awards Daniel's spouse, Mia, $2.4 million from the account, which bucket does it come from? If Daniel's legal team isn't careful, the QDRO might pull the entire $2.4 million from the Roth sub-accounts, leaving Daniel with nothing but the heavily taxed traditional funds. Conversely, if Mia's team doesn't specify the sub-account, the plan administrator might default to a pro rata distribution, which could still be inefficient. Historical trends in California courts show that forensic accountants are now assigning a tax-adjusted value to these buckets. They might argue that $1 in the mega backdoor Roth bucket is actually worth $1.40 compared to $1 in the traditional bucket. Step by step, you must ensure that your valuation expert calculates the embedded tax liability of every sub-account before the final settlement is signed. Another high-stakes element of the Executive 401k is the net unrealized appreciation or NUA strategy. This is particularly relevant for long-term employees at companies like Apple, Microsoft, or ExxonMobil, where a large portion of the 401k is held in company stock. Under IRS rules, if you take a lump sum distribution of company stock from a 401k, you only pay ordinary income tax on the cost basis of the shares. The growth or the appreciation is taxed at the much lower long-term capital gains rate. Consider a case study from the Houston Energy Corridor. We will look at Sarah, a senior director who has been with her company for 25 years. Her 401k contains $2 million worth of company stock that was originally purchased for only $200,000. If Sarah and her husband, James, divorce in 2026, the NUA treatment is a massive hidden asset. If the stock is rolled over into an IRA as part of the divorce, the NUA tax benefit is destroyed forever, and the entire $2 million will eventually be taxed as ordinary income. However, if the QDRO is structured to allow for a specialized distribution where the stock is moved to a taxable brokerage account, the tax savings could be upwards of $300,000. In 2026, we are seeing more cases where the spouse who gives up the NUA benefit is compensated with other assets, such as the primary residence or a larger share of a standard brokerage account. The 2026 market environment adds a layer of volatility that makes these valuations even more precarious. We are currently navigating a period where high-growth tech stocks, which dominate many executive 401ks, are experiencing rapid swings due to AI-driven sector shifts. If Daniel's San Jose 401k was valued at $4.8 million on the day of filing, But a quarterly earnings report causes his company's stock to drop by 20% before the QDRO is processed. Who bears that loss? Potential outcomes depend entirely on whether the QDRO was written as a specific dollar amount or a percentage of shares. In a falling market, a dollar amount award is a disaster for the account holder, as they must liquidate a larger percentage of their remaining shares to satisfy the debt. In a rising market, the recipient spouse misses out on the gains. The step-by-step detail for a high-net-worth professional is to include gain/loss language in the QDRO, which ensures that the award fluctuates with the market until the date of actual transfer. Beyond the numbers, there is the issue of information asymmetry. In many executive households, the working spouse has a deep understanding of the plan's nuances, while the non-working spouse may only see the high-level balance. This insider knowledge can lead to a disparity in the split. For example, some executive plans allow for in-plan loans that don't appear as a balance reduction on the primary statement, or they may include specialized insurance products wrapped inside the 401k. Forensic discovery in 2026 involves requesting the plan document and the individual benefit statement, not just the summary statement. These documents will reveal if there are any blackout periods or specific liquidation rules that could delay a spouse from accessing their funds for months or even years. Furthermore, we must address the restricted stock unit, or RSU trap. While RSUs are technically separate from a 401k, many executives in cities like Austin or Seattle view them as part of their total retirement package. In 2026, companies are increasingly offering 401k swaps, where an executive can choose to have a portion of their bonus or vested RSUs funneled into a non-qualified deferred compensation plan. These plans are often managed by the same administrator as the 401k, and they appear on the same web portal. However, these are not 401ks. They are not protected by ERISA law, they are subject to the company's creditors, and they cannot be split using a standard QDRO. If a divorce attorney treats a deferred compensation plan like a 401k, the resulting order will be rejected, and the spouse may find themselves with no legal way to claim their share of that specific asset. The executive 401k is a masterpiece of financial engineering, but in a divorce, that engineering can be used as a shield or a sword. Whether you are navigating the tax-free growth of a mega backdoor Roth, the capital gains advantages of NUA, or the volatile swings of a concentrated stock position, the complexity requires more than just a lawyer. It requires a strategist who understands the 2026 tax code. As we have seen, the more money involved, the more ways there are to lose it to taxes, penalties, and market timing. But even if you master the executive split, there is one final boundary you cannot cross without a map. Every state in the union has its own philosophy on what fair actually means. A 401k split in California is a completely different animal than a split in Texas or Florida, even if the balances are identical. In the next part of our masterclass, we are going to look at the Great American Divide, community property versus equitable distribution. We will explore how your zip code determines your retirement destiny, and why moving across state lines during a divorce can be a multi-million-dollar mistake. Stay tuned for Part 7, where we map the legal geography of the 401k. The legal geography of the United States is divided by an invisible line that dictates exactly how your 401k is carved up, and in 2026, this line has never been more relevant. On one side of this divide, you have the 9 community property states, including economic giants like California, Texas, Washington, and Arizona. On the other side, the vast majority of the country operates under the principle of equitable distribution. If you are standing in a high-rise in Seattle, your 401k is subject to a fundamentally different set of mathematical rules than if you were standing in a brownstone in Brooklyn or a condo in Miami. Understanding these regional philosophies is the only way to navigate the multi-million-dollar decisions that await you in the courtroom. In community property states like California or Texas, the law generally operates on a rigid mathematical baseline. Anything earned from the moment you say "I do" until the moment you legally separate is owned 50-50 by the marital estate. Imagine if you are Christopher, a lead systems architect in Austin, Texas. It is May 2026, and Christopher's 401k has reached a total value of $900,000. He earned $700,000 of that value while married to his spouse, Elena. In a Texas court, the judge does not care if Christopher worked 80 hours a week in a high-stress tech environment, while Elena pursued a low-income passion project or stayed home. The law views them as a single economic unit. Elena is entitled to $350,000 of that growth by default, Historical trends in community property states show that judges have very little discretion to deviate from this mathematical split, unless there is a valid prenuptial agreement in place. The focus is not on what is fair in a moral sense, but what is equal in a ledger sense. Now let's fly across the country to a city like Miami or New York City to see how the other half lives. We will look at a case study involving Isabella, a specialized surgeon in Miami. Isabella has a 401k worth $1.5 million, almost all of which was accumulated during her 12-year marriage to Julian. Florida is an equitable distribution state. Here, equal is merely the starting point, but fair is the finish line. In an equitable distribution jurisdiction, the judge has the power to look at the totality of the human circumstances. If Isabella's husband, Julian, has a significant inheritance of his own, or if he has a high-earning career that provides him with immense future security, the judge might decide that a strict 50-50 split of Isabella's 401k is actually unfair. The court might award Julian only 30 or 40% of the marital portion. Conversely, if Julian sacrificed his career to support Isabella through medical school and residency, the judge might award him 60% of the account to compensate for his lost earning capacity. In 2026, with the rising complexity of dual-income professional households, we are seeing more equitable distribution cases where the final split looks more like a customized 60-40 or 70-30 arrangement, rather than a mirror image. Step by step, the court in an equitable distribution state evaluates a long list of statutory factors. These include the duration of the marriage, the economic circumstances of each spouse, the contribution of each spouse to the education or earning power of the other, and the desirability of retaining the asset intact and free from any claim or interference by the other spouse. If you are a high earner in Chicago or Philadelphia, your legal strategy must involve building a narrative that justifies an unequal split in your favor, based on these specific factors. This brings us to the transmutation trap, a phenomenon that can turn separate property into marital property in the blink of an eye. Imagine if Christopher and Austin had $200,000 in a 401k before he ever met Elena. During the marriage, he decided to roll that $200,000 into a new 401k provided by a different employer to take advantage of better investment options. He then continued to contribute marital funds from his paycheck into that same new account. Over 10 years, he commingled his separate premarital money with marital money. In the eyes of many courts in 2026, this act of commingling can lead to transmutation. Christopher might argue that the original $200,000 is still his separate property, but the burden of proof is on him. If he cannot provide a flawless, unbroken paper trail of every trade, every dividend reinvestment, and every administrative fee from 2016 to 2026, the court may rule that the entire account has been transmuted into community property. This is why forensic accounting has become a cornerstone of urban divorce litigation. The cost of a missing statement from 5 years ago can be half of your initial investment. The most dangerous scenario in 2026, however, is the cross-state move. We are living in an era of unprecedented professional mobility. Consider the case of James and Sarah. James is a consultant who spent 15 years building a $2 million 401k in Seattle, a community property state. In early 2026, the couple moves to Illinois, an equitable distribution state, to be closer to family. 6 months later, they file for divorce. Which state's laws apply? Generally, the laws of the state where you file for divorce will govern the distribution of your assets. By moving to Illinois, James has traded the mathematical certainty of a 50-50 split for the judicial discretion of an equitable distribution court. In Illinois, a judge might decide that Sarah needs more than 50% of the 401k because James has a much higher earning potential in the consulting world. If they had stayed in Seattle, James would have likely kept exactly half. By moving across state lines, James may have inadvertently lost hundreds of thousands of dollars in future retirement security. To mitigate these risks, professionals in modern American cities must perform a 3-step audit of their legal geography. First, you must identify your state's classification and the specific local rules regarding the date of separation. In some states, the marital portion of the 401k stops growing the day you move out. In others, it continues until the day the judge signs the final decree. Second, you must perform a characterization of every dollar in the account. Is it separate, marital, or a mixed asset? Third, you must evaluate the active versus passive appreciation of the account. In 2026, if your 401k grew because of your active management and stock picking during the marriage, some states will treat that growth as a marital product of your labor. If it grew simply because the market went up, It might be treated as passive appreciation of a separate asset. Potential outcomes in these cases are rarely dictated by the total balance alone. They are dictated by the intersection of state law, the quality of your financial records, and the narrative presented to the court. We have seen historical trends where a well-prepared spouse in a fair distribution state walks away with a significantly better outcome than they would have in a community property state, simply by highlighting the economic realities of their post-divorce life. But what if you want to take the power away from the state entirely? What if you want to decide the fate of your 401k years before a divorce is even a possibility? There is a legal shield that can override the geography of the United States and the discretion of any judge. In the next part of our masterclass, we are going to look at the ultimate defense mechanism, prenuptial and postnuptial agreements. We will explore how to bulletproof your 401k against state laws, and why the way you draft these documents in 2026 is the difference between a secure retirement and a legal disaster. We will look at the specific clauses that protect your compound interest and the mistakes that make these contracts worthless in court. Stay tuned for Part 8, where we enter the world of the marital contract. The marital contract is the only document capable of overriding the default software of state law. In the high-stakes professional environments of cities like San Diego, Charlotte, or Denver, where 401k balances in 2026 can represent decades of hyper-focused career growth, the prenuptial agreement serves as a custom-coded firewall. It allows couples to opt out of the community property or equitable distribution systems we discussed previously and create a private set of rules. However, in the world of retirement accounts, a contract is only as strong as its compliance with federal law. Many high-earning professionals believe that simply signing a piece of paper before the wedding bulletproofs their assets. Historical trends suggest that without a specific, two-step execution process, even the most expensive prenuptial agreement can be dismantled in a matter of minutes during a divorce. Imagine if you are Alexander, a senior software architect in San Diego. It is 2026, and Alexander has spent the last decade building a 401k valued at $850,000. Before marrying his partner, Chloe, Alexander insisted on a prenuptial agreement. The contract stated clearly that his 401k, including all future contributions and all future market appreciation, would remain his separate property in the event of a divorce. Alexander felt secure. He believed he had neutralized California's aggressive community property laws. The first major complication Alexander faces is a federal statute known as ERISA, or the Employee Retirement Income Security Act. Under ERISA, a spouse has a federal right to be the beneficiary of a 401k. A person who is not yet a spouse, a fiancé, cannot legally waive their rights to a 401k because they do not yet hold the legal status of a spouse. This is the ERISA waiver trap. In 2026, we are still seeing cases where individuals like Alexander sign a prenup, get married, and then assume the work is done. But because Chloe signed the waiver before she was legally his spouse, the waiver is often considered invalid by the plan administrator and federal courts. Step by step, the only way to protect a 401k through a marital contract involves a secondary action. After the wedding ceremony is over and the marriage certificate is filed, the new spouse must sign a formal waiver provided by the 401k plan administrator. This is a post-marriage confirmation of the prenuptial intent. If Alexander fails to get Chloe to sign that specific HR document after the wedding, his premarital contract regarding the 401k may be essentially worthless. Potential outcomes for those who miss this step include the court ruling that the 401k became marital property the moment the marriage began, regardless of what the prenup said. Now, consider a different scenario involving a postnuptial agreement in a city like Atlanta. We will look at Maya, a pharmaceutical executive. Maya did not have a prenup, but 5 years into her marriage, her 401k grew exponentially due to a series of successful company stock maneuvers and high-performance bonuses. In 2026, recognizing the volatility of the market and the increasing complexity of their marital estate, Maya and her husband, David, decided to draft a postnuptial agreement. A postnuptial agreement in 2026 requires a higher standard of scrutiny than a prenup. Because the couple is already married and owes each other a fiduciary duty, the court looks for any sign of coercion or unfairness. For Maya's 401k protection to hold up, the agreement must include full and fair disclosure of all assets. If Maya fails to disclose even a small secondary retirement account from a previous employer, the entire contract could be tossed out as unconscionable. Furthermore, Both Maya and David must be represented by independent legal counsel. In the urban legal markets of the United States, if one spouse uses a lawyer recommended or paid for by the other without a clear conflict waiver, the contract is viewed with extreme suspicion. The most critical clauses in these 2026 contracts involve the definition of appreciation. There is a massive legal difference between active and passive appreciation. Passive appreciation is the growth of the account due to the market going up. Active appreciation is growth caused by the efforts of one of the spouses, such as choosing specific stocks or making additional contributions from a marital salary. A well-drafted marital contract must specify that all appreciation, whether active or passive, remains separate property. Without this specific language, a spouse in an equitable distribution state like Georgia might argue that because they managed the household while the other spouse focused on their 401k investments, they contributed to the active growth of that account. Historical trends show that the most successful marital contracts in high-cost cities use a tiered distribution model. For example, the contract might state that if the marriage lasts less than 5 years, the 401k remains 100% separate. If the marriage lasts 10 years, the spouse receives 20% of the growth. This sliding scale approach is often viewed by judges as more equitable and less likely to be challenged as a contract of adhesion. Forensic documentation is the second half of the marital contract strategy. Even with a perfect legal document, you must be able to prove the starting balance. In 2026, forensic planners suggest creating a digital asset vault at the time the contract is signed. This vault should contain a certified statement of the 401k balance on the day of the marriage, a copy of the plan's summary description, and a record of the underlying investment holdings. If you claim in your prenup that $500,000 is separate, but 10 years later you cannot prove where that money was invested or how it moved between accounts, you risk a commingling ruling that overrides your contract. We are also seeing a rise in lifestyle clauses within 2026 postnuptial agreements in cities like New York or San Francisco. While these are often controversial, some couples include provisions that link 401k distribution to specific life events. However, U.S. courts are generally hesitant to enforce clauses that move retirement funds based on behavior. The core of the 401k contract remains the financial ledger. The goal is to create a clear, unambiguous map of what belongs to the individual and what belongs to the partnership. In the modern American city, where divorce rates for high-stress professional couples remain significant, the marital contract is a tool of clarity. It removes the what-if from the retirement equation and allows both parties to understand their financial trajectory. But even with a bulletproof prenup and a perfectly executed post-marriage waiver, there is one final document that actually moves the money. This is the document that sits between the judge's order and the brokerage's action. It is the most technical, most boring, and yet most dangerous piece of paper in the entire process. You can have the best contract in the world, but if the qualified domestic relations order is drafted incorrectly, your 401k will be stuck in legal limbo for years, or worse, liquidated in a way that triggers every tax penalty you were trying to avoid. In the next part of our masterclass, we are going to deconstruct the QDRO itself. We will look at the exact phrases that must be included to satisfy both the IRS and the plan administrator. We will explore the model language traps and why using a standard template is the fastest way to lose your retirement. Stay tuned for Part 9, where we master the mechanics of the QDRO. The Qualified Domestic Relations Order, or QDRO, is the single most important document in the entire process of asset division, yet it is frequently treated as an afterthought or a clerical formality. In the professional corridors of cities like Charlotte, North Carolina, or Columbus, Ohio, where corporate 401k plans are the bedrock of the middle class, a failure to master the mechanics of this document can result in a catastrophic loss of value. To understand the QDRO, you must first understand the word qualified. It means the order must meet the strict requirements of both the Internal Revenue Code and the specific rules of the employer's retirement plan under ERISA. If the document is not qualified, it is just a piece of paper signed by a judge that the plan administrator can and will ignore. Imagine if you are Michael, a senior vice president at a major financial institution in Charlotte. It is 2026, and Michael's 401k is valued at $1.1 million. In his divorce settlement with his spouse, Jennifer, the parties agreed to a 50-50 split of the marital portion. Michael's attorney used a standard one-size-fits-all QDRO template downloaded from a legal database. The document was signed by a local judge and sent to the plan administrator. 3 weeks later, it was rejected. Why? because the template used the phrase the marital portion, which is a legal concept, but the plan administrator only speaks the language of mathematical formulas. The plan document required a specific date of valuation and did not recognize the term marital portion as a valid instruction for a distribution. While Michael and Jennifer's attorneys spent the next 2 months arguing over a revision, the market experienced a significant correction in early 2026, and the value of the account dropped by 15%. Because the original intent was vague, a new dispute arose. Should Jennifer receive half of the original $1.1 million or half of the new lower balance? Historical trends in urban family law show that the model language trap is the leading cause of these delays. Most large employers in cities like Houston or Chicago provide a model QDRO form to employees. On the surface, this seems helpful. However, these model forms are drafted by the company's lawyers to protect the company, not you. They often default to the simplest, most restrictive methods of distribution. For example, a company's model language might default to a shared interest approach rather than a separate interest approach. To navigate this, we must deconstruct the difference between these two mechanical pathways. Under a shared interest approach, the ex-spouse, known as the alternate payee, only receives a portion of the actual pension or 401k payments when the participant spouse starts taking them. This keeps the ex-spouse tied to the participant's life and retirement choices for decades. In 2026, the gold standard for 401k division is the separate interest approach. This method takes the designated portion of the 401k and carves it out into a completely independent account for the ex-spouse. Once the separate interest QDRO is qualified, Jennifer in our Charlotte case study would have her own account, her own login, and the ability to choose her own investments and her own retirement date, completely independent of Michael's future career moves. Step by step, the drafting process must include 3 critical mechanical clauses that templates often miss. First is the gains and losses clause. In the volatile market of 2026, you must explicitly state whether the alternate payee's share will be adjusted for market fluctuations between the date of valuation and the date of actual distribution. If the market goes up 10% while the paperwork is being processed and your QDRO doesn't mention gains, the participant spouse keeps the entire windfall. If it goes down and you don't mention losses, the participant spouse is forced to overpay from their remaining share. Potential outcomes of omitting this clause include immediate post-divorce litigation that can cost more than the market movement itself. Second is the surviving spouse protection clause. What happens if Michael passes away after the judge signs the divorce decree, but before the plan administrator officially qualifies the QDRO? In many plans without specific protective language, the alternate payee's right to the 401k dies with the participant. The QDRO must designate the ex-spouse as the surviving spouse for the purpose of the portion of the benefit being assigned. In the high-stress environment of 2026, where administrative backlogs can result in a 3 to 6 month wait for QDRO qualification, this clause acts as a vital insurance policy for the recipient spouse. Third is the specificity of the plan name. This sounds trivial, but it is a frequent point of failure. In an era of constant corporate mergers and acquisitions, a 401k plan might change names 3 times in 5 years. If you are a professional in a city like Phoenix or Atlanta, your company might have a savings and investment plan, a retirement wealth plan, and a profit-sharing plan all managed by the same brokerage. If your QDRO simply says the 401k plan, the administrator will reject it for lack of specificity. You must use the exact legal name of the plan as found in the summary plan description. The 2026 market has also introduced the complexity of the pro rata versus specific liquidation instruction. When you split a 401k, the money has to come from somewhere. Does it come equally from every fund in the portfolio? Or does it come from the most stable value fund first? If the participant spouse has a portfolio with 60% tech stocks and 40% bonds, a pro rata instruction means both spouses end up with the same risk profile. However, if the recipient spouse is closer to retirement, they might want their half pulled only from the stable assets. The QDRO must be the bridge between the financial reality and the legal order. We must also revisit the tax mechanics within the QDRO itself. We touched on the 20% federal withholding in earlier parts, but the QDRO must specifically state who is responsible for the taxes. Under federal law, for a 401k split between spouses, the alternate payee is generally responsible for the income tax on the distribution they receive. However, if a QDRO is used to pay child support from a 401k, the participant spouse, the one who earned the money, is the one responsible for the taxes. In 2026, We are seeing more cases where creative attorneys try to shift the tax burden through the QDRO language. If you are the participant, you must ensure the document explicitly identifies the alternate payee as the party responsible for all federal, state, and local taxes associated with their distribution. Finally, the execution phase requires a pre-approval strategy. You should never send a signed QDRO to the court without first sending a draft to the plan administrator. Most large plan providers in cities like Denver or San Francisco have a dedicated QDRO department. By getting a pre-approval letter, you ensure that once the judge signs the document, it will be accepted on the first try. This avoids the logistical nightmare of having to return to court to ask a judge to sign an amended order, because the plan administrator didn't like the font or the phrasing of a specific paragraph. As we master the mechanics of the QDRO, it becomes clear that this is a technical surgical strike on a retirement account, not a general negotiation. You are dealing with federal law, corporate bureaucracy, and market volatility all at once. But even if you draft the perfect QDRO, and even if the money moves seamlessly into separate accounts, the journey isn't over. The financial split is the end of the legal process, but it is the beginning of the most difficult part of the 401k divorce: the psychological and strategic rebuild. How do you recover from a 50% loss of your retirement trajectory? How do you adjust your life goals when the compound interest machine has been cut in half? In the final part of our masterclass, we are going to look at the post-divorce recovery plan. We will explore the 2026 strategies for aggressive catch-up contributions, the psychological shifts required to manage a smaller nest egg, and how to ensure that your new independent financial life is built on a foundation that can never be dismantled again. Stay tuned for Part 10, the final chapter, the rebuild. The silence of a divided retirement account is one of the most sobering experiences an urban professional can face. You log into your portal in early 2026, and the number staring back at you is exactly half of what it was 6 months ago. The compound interest machine you spent 20 years oiling has been dismantled. For many in cities like San Francisco, Seattle, or New York, the immediate instinct is panic. There is a sense that the timeline has been permanently broken. However, the rebuild is not just about replacing lost dollars. It is about utilizing the specific financial landscape of 2026 to construct a more resilient, solo-focused trajectory. This final chapter of our masterclass is the blueprint for that recovery, focusing on aggressive tax-advantage strategies, the psychological shift from a joint to an individual timeline, and the administrative cleanup that prevents your ex-spouse from haunting your financial future. Step 1 of the rebuild begins with the IRS contribution limits for 2026. In the current fiscal year, the standard contribution limit for a 401k has adjusted to $24,500. But for those navigating a post-divorce recovery, the catch-up provisions are the most critical tools in the shed. If you are age 50 or older, you are eligible for an additional catch-up contribution of $8,000. But there is a 2026 specific nuance you must understand. Under the implementation of the Secure Act 2.0, if you earned more than $145,000 in the previous year, your catch-up contributions must now be made into a Roth account on an after-tax basis. This is a fundamental shift for high-earning urban professionals. While you lose the immediate tax deduction, you are effectively building a tax-free bucket of capital that will be vital in a solo retirement where you no longer have a spouse's lower tax bracket to hedge against. Imagine if you are James, a 55-year-old engineering lead in Seattle. After his 401k was split, his balance dropped from $1.2 million to $600,000. James feels like he has lost a decade. However, James is now in the super catch-up window introduced for those aged 60 to 63, which allows for even higher contribution ceilings in 2026. By maxing out his primary contribution and utilizing the super catch-up, James is funneling over $35,000 a year into his account. Because he is now a single filer, his tax brackets have shifted. Step by step, James must recalculate his effective tax rate. Without the ability to file a joint return, James may actually find himself in a higher bracket even with a lower total household income. This makes the 401k contribution even more valuable as a tool to lower his modified adjusted gross income and potentially qualify for other deductions that were previously phased out. The second pillar of the rebuild is the asset allocation reset. Most couples have a joint risk profile that averages their ages and risk tolerances. When you are suddenly a solo investor in 2026, your risk tolerance must be reevaluated. If you are the spouse who kept the house but lost half the 401k, You are now overweighted in real estate and underweighted in equities. Historical trends suggest that many divorcees fail to rebalance their total net worth after a split. If 60% of your remaining wealth is tied up in a Chicago condo, you may need to be more aggressive with your remaining 401k investments to capture market growth. Conversely, if you are 10 years from retirement and your nest egg was just cut in half, you might feel the urge to chase returns by investing in high-risk sectors like speculative tech or volatile commodities. This is a potential outcome of the panic rebuild phase that often leads to further losses. The 2026 strategy requires a surgical rebalancing that views your 401k not in isolation, but as the liquid counterweight to your other post-divorce assets. We must also address the secret 401k for the modern professional, the Health Savings Account or HSA. In 2026, the HSA has become a primary retirement vehicle for those in high-cost cities. If your employer offers a high-deductible health plan, the HSA allows you to contribute $4,300 as an individual. This money is triple tax-advantaged. Tax-deductible going in grows tax-free, and is tax-free coming out for medical expenses. After age 65, it can be used for any purpose, effectively functioning like a traditional 401k. For someone like James in Seattle, maxing out an HSA alongside his 401k creates an additional layer of tax-sheltered growth that can help bridge the gap created by the divorce split. The third pillar is the administrative firewall. This is the most common point of failure in the years following a divorce. Even if your QDRO is finalized and your money is moved, your 401k is still governed by the beneficiary designations on file with your plan administrator. In many states, a divorce decree does not automatically revoke a beneficiary designation on a federal ERISA-governed 401k. There are hundreds of case studies where an individual worked for another 15 years after a divorce, built their 401k back up to 7 figures, and then passed away, only for the money to be paid out to the ex-spouse they hadn't spoken to in a decade because they never updated the portal. Step by step, the very first task after your account is segregated is to log in and update your primary and contingent beneficiaries. In 2026, many plans now allow you to designate per stirpes, or to a living trust, providing a layer of protection for your children or other heirs that your ex-spouse cannot penetrate. Furthermore, we must look at the psychological recovery. There is a concept known as sequence of returns risk that becomes magnified after a 401k divorce. If the market performs poorly in the first 3 years of your rebuild, the psychological impact can be devastating. However, the historical trend of the US market shows that time in the market is more significant than the starting balance. By consistently contributing in 2026, you are engaging in dollar cost averaging at a time when your contributions represent a larger percentage of your total account value than they did when the account was at its peak. This means your new contributions have a disproportionately high impact on your future recovery. Finally, we have to consider the role of professional help in the new solo landscape. In your married life, you may have used a generalist financial planner. In your post-divorce life in a city like Boston or Austin, you need a specialist. You need someone who understands the single filer tax traps and the specific 2026 rules for Roth conversions. Many professionals are now using laddered conversions to move their remaining traditional 401k funds into Roth IRAs during the lower income years immediately following a divorce. This allows you to pay the tax at a lower rate now, ensuring that your rebuilt nest egg is entirely yours, free from the future claims of the IRS or a future partner. The 401k divorce is a transition that tests the limits of financial and emotional endurance. But in the modern American city, where wealth is built on the back of professional expertise and disciplined saving, the half-life of a retirement account is shorter than you think. By mastering the 2026 contribution rules, rebalancing your risk to fit your new reality, and securing your beneficiary firewall, you aren't just surviving the split. You are optimizing for a new kind of freedom. Your future is no longer a joint venture with a compromise partner. It is a solo expedition where you keep 100% of the growth, 100% of the interest, and 100% of the peace of mind. While the 401k is the largest liquid asset you have split, it is often just the beginning of the legal cleanup. As you move into this new phase of independence, your attention must shift to the document that controls every other aspect of your existence. While you've secured your retirement, who secures your medical decisions, your remaining property, and your legacy if you are no longer a part of a legal pair. The 401k was about your life in the office. The next challenge is about your life in the long term. Stay tuned for our next deep dive series where we look at the total estate reset, and how to bulletproof your solo legacy in an era of digital assets and shifting inheritance laws. This is the end of the 401k masterclass, but the beginning of your new financial era.